In parental rights news, a new federal lawsuit is raising an age-old question. Under what circumstances do we remove children from the homes of their parents? And when we make the decision to do that, how do we go about doing it? So we have a twofold problem. When do we make the decision? And how do we execute that decision? When is the right time, if ever, to remove a child from a family home? And we can sort of think about like the worst problems that we're trying to solve here when there should be probably some intervention. But how do you draw the line? Where do you draw the line? What is the process for it? All those things. And this lawsuit re-raises that question when it comes to issues of parental rights and due process. So let's learn a little bit more about this particular lawsuit. Let's get started with this. When child welfare workers and police knocked on Sarah Perkins and Joshua Sabby's front door well past midnight one weekend last summer in Boston, Massachusetts, the parents were shocked to learn that it was there. They were there because they were there to take away their children. So we're in Boston, Massachusetts. There's a knock on the door. We're here for your kids. It's a kind of harrowing scene that plays out daily across the country as social workers, who are often motivated by a desire to protect children, run up against confused and concerned parents, and also sometimes for reasons that seem a little bit more questionable when it comes to the fairly extreme step of terminating or interfering with parental rights. What followed this session in Boston was, of course, emotional anguish, bureaucracy, vindication for the parents, and a lawsuit filed last month. So in the end, the parents won. And now the issue is, well, at least in part, how did they make the decision, and what's coming at midnight with police really the best way to handle this? So the couple has sued and hopes that a ruling in their favor might help to rectify some of these issues on a nationwide basis when we get to some of these fundamental issues when it comes to parental rights. In the particular case at hand, the children were taken by the state of Massachusetts because of a child abuse report stemming from a hospital visit. On July the 13th of 2022, the parents whisked their son to the emergency room because he had a 103-degree fever. So yeah, that would get my attention. Potentially as a parent, 103 degrees is a pretty hot temperature for a 3-month-old in particular. So yes, that would definitely get my attention. And it's like, yes, we should probably do something about that. So let's take them to the hospital. During the medical care that they received, apparently an x-ray, which was there to check for pneumonia, followed some kind of rib fracture that the couple hadn't noticed. After speaking with the boy's grandmother, they learned the injury may have happened weeks earlier as she removed the son from a car seat. He slipped, and she caught him with one arm. Citing the fracture, hospital officials reported potential abuse to the Department of Children and Families. Okay, so what we have over here is perhaps some overly cautious hospital officials, although to some degree, they may not have a choice because, of course, they're mandatory reporters. So if they believe that this is child abuse situation, they have to report it. And maybe out of a desire to cover their own ass, they take the position that anything that even could potentially smell at any level like child abuse is something we need to report. Let someone else figure it out so that we're not stuck holding the pile of poo, right? Deflection, we will report everything. Maybe that's what we're doing. So we've found this child. They have a 103-degree fever. We've done an x-ray checking for the pneumonia. We found a rib fracture on the child. So we say, aha, this might be potentially child abuse. So let's report it. All right, so that's where we're going so far. Let's learn more. It was such a roller coaster, the total terror that we're going to lose this child at the hospital and then complete relief after we're allowed to go home with a safety plan, the parents said. I bet that would freak you out a little bit. It's like you're doing the child abuse. What? No. They returned to their home. The Department of Child Services made a surprise visit and found no evidence of abuse, according to the lawsuit. So initially, they're allowed to go home from the hospital with some kind of safety plan. So we think maybe the rib fracture occurred when, grandma over here was picking up the child out of the seat and perhaps slipped out of her arms a little bit. We were able to catch the child, but, in doing so, we, you know, snapped our arm because, that's how one would do that. And, we cracked a rib as we were doing it. We didn't notice this happened at the time, but, it makes sense. So it's like, okay, here's how to try to avoid those problems. Okay, well, thank you for the advice. Then child welfare comes over here and inspects the home. No problems. All right, everything seems fine. Days later, however, child welfare over here and police knocked at the door to take the sons away. They didn't have a warrant or a court order, neither of which is required to remove a child in Massachusetts. So, which seems odd, incidentally, because of course we are entering a home and also we are seizing a person, namely the child. But apparently we don't need a warrant for that. We don't need a warrant to enter your home. We don't need a warrant to seize the child. So this doesn't appear to be exigency, right? It's not that we have some immediate evidence on the scene right now that a crime is taking place right this second, or there's an immediately dangerous situation. So this doesn't appear to be exigency. This doesn't appear to be, hot pursuit. It's not like we're pursuing a fleeing felon. So in the absence of exigency, in the absence of that evidence, we're still doing the warrantless search anyway, and the warrantless seizure. I suppose we're going to try to claim exigency, even though we found no evidence of abuse, which is a weird kind of exigency, but that's what we're going to try to cram this into, I'm sure. It was intense. We see these police officers are armed. We're asking for paperwork, and there is none. Eventually, we're told we either have to hand over the kids, or they're going to break down our door and take them by force. Which at that point, I'd be like, break down the door. I mean, I'm not opening the door for you. So, if you have the right to break down the door, break down the door. I'm not going to hand you over my kids, but that's just me. Within 24 hours, the parents were allowed to act as foster parents. 4 weeks later, Department of Child Services over here let the parents of the children take the children home. And after another 3 months and $50,000 a fee, the government restored full custody. A short time later, the couple moved to Idaho, apparently not so thrilled with the predations of the fine government of Massachusetts. The couple's lawsuit alleges constitutional violations, including unreasonable search, unreasonable seizure, and deprivation of parental rights without due process. Yeah, that sounds all real promising, right? What is our basis to enter the home? What is our basis to seize the child? What is the basis to terminate our rights? Do you have imminent evidence of abuse? Do you have exigency? Are you trying to catch a fleeing felon in hot pursuit? No, none of those things. So why are you able to do this? That's a really, really good question. So yeah, that seems like a prudent lawsuit. The couple are plaintiffs in a lawsuit filed by the Pacific Legal Foundation, which is a nonprofit focused on parental rights and other issues and does a lot of great work in this domain. They are somewhat akin to what the ACLU used to be in some respects, not quite the same in sort of their focus, but similar in sort of what they do in some respects. They are a civil rights group that fights a lot of these cases and quite successfully as well. So the Pacific Legal Foundation being involved is a very good sign. It's also part of a legal strategy to set precedent nationwide, confirming the importance of parental rights and clarifying the need to include a neutral judge in removal decision unless imminent harm, exigency. So yes, if the evidence is perhaps really, really strong or something, in which case we probably don't give the children back to the parents at the hospital. We probably would seize them from there at that point if the evidence is that good. But, in any case, we should probably get judges involved in these things more often. The lawsuit names the individual social workers, police officers in the city, but not the Department of Children's Services itself. That's in part because state agencies can't be sued in federal court for damages because of the Constitution. So yes, because of the nature of the 11th Amendment, you can't really sue them, except, of course, under limited circumstances, which aren't immediately present here. So we can sue the state, we can sue the workers, police officers in the city, but not the department because it's a statewide agency under these particular circumstances. So that makes logical sense, but we'll go about it a different way. In a different case, a woman named Joyce McMillan wasn't as fortunate as our protagonist in this story. Joyce relied on a public defender 23 years ago when her two children were removed after a drug test turned up a positive for what a New York resident described as an illicit substance. But she had a job, a home, and she was providing for her children. A drug test is not a parenting test, she said. So, yeah, maybe she has drugs in her system of some kind, but that isn't necessarily an indication unto itself as to her parental ability. Maybe it should be a sign for further investigation. Maybe it should be a sign for some concern. But is it enough in and of itself? Probably not. There are a lot of parents out there probably, hitting the bottle or doing the equivalent, but are nevertheless good parents. So is drug use a concern? Sure, because it often can be associated with abuse, but is not necessarily indicative in every case. The woman in the other case said she fell into a depression and became homeless as a result before getting her children back 2 years later because of the bureaucracy. She is currently executive director for a non-for-profit relating to families. The group advocates for dismantling the child welfare system as it currently exists, which it calls a family policing system, which, to be fair, that is not an unreasonable thing to say that the system needs to be changed in some sort of systematic way. So do we need to dismantle the system? I don't know if we need to do that because the system does have a point. So dismantling child welfare might be a little bit like saying, let's dismantle the police. Or maybe we want to run this all through the police system instead of child welfare. Maybe we want to do it that way. But there is some legitimate purpose, but whatever legitimate purpose it has, it might be time for a stronger look because sometimes, the bureaucrats take the children for less than noble reasons. And we need to be really cautious as we are interfering with parental rights. A bill that is currently pending before Massachusetts would require children welfare workers to get judicial approval within 4 hours of removing a child. So we want to get a warrant after the fact, which might be a little late, again, dealing with the issues when it comes to seizure. So we still want to do the seizure, but get a warrant after the fact. I'm not really 100% sure that solves the problem. It would also make it easier for workers to contact judges outside of regular hours, including overnights on weekends, which that part shouldn't be that much a problem. There's almost inevitably a judge on call 24/7 for example, roadside stop blood draws, So yes, there's typically a judge on call somewhere at 3 a.m. so that you can get this kind of process, especially in major cities, though obviously that might not necessarily be true everywhere. So in more rural counties, maybe not so much, but in major cities, there's probably a judge on call. Night court was based on some kind of reality. An estimated 3 million children came under the scrutiny of various child welfare agencies in 2021, which seems like a lot. 3 million children? Holy shit. That's a lot of children. And maybe some of that's warranted. But how are we dealing with that when it comes to the parents of the 3 million children? According to the Department of Health and Human Services, 600,000 were victims of mistreatment. But how are we defining mistreatment also is a bit questionable in terms of what we define as mistreatment. An estimated 1,800 children died during the same time interval due to various mistreatments, which obviously is horrible. That shouldn't happen. 2,000 children dying every year because of parents mistreating them. That's really, really bad. We should try to figure out how to solve that problem. But we should try to figure out how to solve that problem in a way that protects people's due process rights. Children, of course, are protected by the Constitution just as much as their parents are. And when their parents are behaving in ways that are abusive, ill-treating, when they are verbally abusive, when they're physically abusive, when they're chemically abusive, psychologically abusive, when they are doing things that hinder their child's growth, locking them in a closet, locking them in the room for extended periods of time, that kind of thing, then there is a role for the state to be had. Children do have rights, and the state has an interest in protecting the children who also are people of the United States. So yes, we should sometimes intervene, But just because we should sometimes intervene doesn't mean we should intervene all the time. So it is a matter of degree, and perhaps we've gone too far in some cases. The president-elect of the National Association of Social Workers says that social workers aren't out to get children, trying to protect them. That might be very well true in many situations. There is often a good and noble motive, but of course, the road to hell is sometimes paved with good intention. So yes, we should sometimes intervene, but sometimes we're intervening in ways that just merely reflects our own personal preferences instead of actual harm to a child. When a hospital, school, neighbor, or older child reports mistreatment, social workers typically apply a risk assessment. The Child Protective Service doesn't create the reports of harm, someone calls us. Yes, that's true, but sometimes it's because they're mandatory reporters. And sometimes it's because they're reporting just because they don't want to run into a problem, right? Why make the distinction about what's really should be reported and what shouldn't be reported? Why not just report everything and make it someone else's problem? So yes, it is because reports are coming to you, but sometimes it's because they're trying to cover their ass, not because it's a real problem. If a child is being seriously abused, they may be very happy to see relief is coming. Yes, I tend to agree. I tend to agree in some situations, but not all situations. It's a matter of nuance. Thus, that brings us to the end of the case dealing with the child welfare situation in Boston, in which parents had a child seized because of a bruise of a cracked rib that the child suffered through a fairly innocent thing. A grandmother was picking up the child slipped, the grandmother, held on to the child and used, in using force as one does because they're reacting suddenly. And because it's a 3-month-old, they cracked the rib because that's perfectly understandable. It's a perfectly normal thing. They didn't even know the injury had occurred, by the way, until until it was discovered at the hospital because there was no external signs of it. But it happened. And then because of this minor issue, they had their child removed without a search warrant, without an arrest warrant, without a detention warrant, in violation of the Fourth Amendment. And the parents over here are saying, hey, no, wait a second, you should have gotten a court order. Also, why are you coming at midnight? Just incidentally, is a good question here. So this lawsuit is going to proceed forward, perhaps bringing some light to some abuses of a system that, while it has its purposes, of course, can be abused like any tool. And the investigation is ongoing. And that, for the moment, brings us to end the discussion of this case.